Okay, now we are done with the nature of the contract. Let's check this mark here. And then now let's proceed with essential elements of form. Essential elements and form of the contract of sale. Okay. So these are the essential elements of a contract of sale. We have one, consent, object, and the price in money or its equivalent. So it bears stressing that the absence of these essential elements negates the existence of a perfected contract of sale. Okay, so let's start first with the first element, which is object. Actually, we can start with the consent, but there are those items that we would refer later, the capacity of the parties, so we will leave it at the last part. Okay, so let's start with the object first. The object of the contract or the subject matter. So anything that has a value that can be assessed in money, whether immovable or movable, consumable or non-consumable, corporeal or incorporeal, present or future, and indeed even a mere hope of or expectancy class, may be the object of sale subject to the rule of the general law of contracts, restricting the objects of contracts to things which are not outside the commerce of men, and to such further conditions that we will be discussing. Okay, so what are the conditions? So the first requisite in order to constitute a valid subject matter in the contract of sale is that it must be licit. Okay, it must be licit and legal. Okay. The second requisite is that it must exist or not at the time of the perfection of the contract, so long as it has the possibility of existence at some future time. The law says that things having a potential existence may be the object of the contract of sale. Okay. Before, people don't really have that idea, or maybe do have an idea, no, but the existence of electric vehicles long time ago in Bethlehem, it seems to be close to impossible. But right now, it do exist, right? So it can be an object of contract of sale. No, there is a possibility of existence at some future time. So the goods which form the subject of a contract of sale may be, existing. So they're already here, owned or possessed by the seller, but then the ownership of the seller of the item being sold is not necessary, okay, for a contract of sale to be perfected, for as long as he has the right to transfer the ownership thereto. Or goods to be manufactured, raised, or acquired by the seller after the perfection of the contract of sale. Take note that in order to be valid, there must be an intention. So here comes the magic word, intention of the parties, to make the delivery of the goods in the future. So if it has been entered into without the intention of having any goods or commodity pass from one party to another, but with an understanding that at the appointed time, the purchaser is merely to receive or pay the difference between the contract and the market prices, it's a transaction which the law will not sanction for being illegal, and the loser may recover what he has paid. Okay? So, of course, the thing must be determinate. So this is the third requisite. No? The thing must be determinate when it is particularly designated or physically segregated from all others of the same class. I've also included here a test in determining whether a thing is determinate. The requisite that a thing be determinate is satisfied if at the time the contract is entered into, the thing is capable of being made determinate without the need of a new or further agreement between the parties. Okay. So the contract must of course complete na siya, no? Hindi na kinakailangan na, we need to draft another contract na naman to identify, ano ba to? Is it gonna be the crop for the next season? Is it gonna be this particular batch will be sold? Diba, may ganun. So, there must be some sort of a reference, no? There's no need for any further agreement. Okay. There may be a contract of sale of goods whose acquisition by the seller depends upon a contingency which may or may not happen. So, what are these example? In the case of a purchase ng lotto ticket, no? If the ticket wins, the price is much more than the price of the ticket. And in aleatory, the consideration is not equivalent to what has been received in the it is not equivalent, no? Kasi yung mga lotto ticket natin, binibili lang natin for a small amount, and then, if you happen to be the luckiest person for that draw, you will really, iuuwi mo talaga yung malaking amount na yon, right? So that's object. And how about things subject to resolutory condition? Can it be a object? Can it be an object of the contract of sale? Yes. If the condition is fulfilled, the parties shall return to each other what they have received. Okay. Now, there is also parang, emptio res perate and emptio spe. So, ilagay natin yan dito para hindi natin malimutan. Emptio res perate. Did I get the spelling right? Perate. Okay. So, what is this emptio res perate? Okay. This is a species of sale of future things in Roman law in which the amount of and the quality of the thing is uncertain. Amount and the quality of the thing is uncertain. Okay, but not the thing itself, for this is definitely to exist, whatever may be the quantity or quality with which. What could be an example of this one? Okay, the sale is subject to the condition. Okay, an example of this could be the next year's crop. No, you don't know the amount and the quality of the thing. What would happen if there will be changes in climate? So, konti lang ba? Marami ba? Diba? So, there are factors to consider, right? But the sale is subject to the condition that the thing should come into existence. So that if the condition is not fulfilled, if the thing does not come into existence, the contract cannot have effect for lack of an essential requisite. Although the vendee may reserve his right to claim indemnity from the vendor in the event that the latter knew that the thing could not come into existence. So, parang good faith, no? On the part of the vendor. Baka sabihin niya naman na, ibibenta ko yung next year's crop, pero alam naman niya na wala din naman pala silang itinanim, di ba? So, may fraud. There's a malice and intent to do something. Bad faith. As simple as that. So, there might be, or the vendee may reserve his right to claim indemnity for damages, no? Now, let's proceed with emptio spe. Ano naman tong emptio spe? Emptio spe. Okay. So, in emptio res perate, we are also, ilagay na lang din natin dito na. It's purchase of something hoped for. Okay. On the other hand, emptio spe refers to a sale or purchase of something hoped for. Sige, to be consistent, let's just say purchase, no? Or sale of something hoped for. Purchase of something hoped for. Say, depende kasi on what perspective would you like to refer to, no? So, purchase of hope. Okay. In this case, while empty res perate is that the sale is subordinated to the condition that the thing should come into existence, in emptius pay, on the contrary, the contract has effect even if the thing does not come into existence. No? Whether anything, okay, there is an example here. Example would be the sale of the next cast of net. So whether anything is caught or not, the price has to be paid. However, the sale of vain hope or expectancy is void. So in purchase of hope, parang nagiging take or pay. No? It's either, whether meron o wala. No? But the sale of a vain hope or expectancy is void. Okay. So I think I've already discussed the determinateness of the object. Now let's proceed with okay. There is a question here. Is it necessary to own the goods at the time? Is it necessary for the seller to own the goods at the time of the perfection of contract? The answer is no. A perfected contract of sale cannot be challenged on the ground of non-ownership on the part of the seller at the time of its perfection. Hence, the sale is still valid, right? So, if you will just imagine, no, you don't have any inventory, okay, but you'd want to sell. And then there's someone who DM'd you or slide a message on your messenger asking you for the price, and then, of course, you have already adjusted it based on considering the shipping cost, the storage fee, and everything in between. You don't own the product, but you're selling it, right? So at the time that the contract is perfected, the ownership of the thing is not required, no, at the time of the perfection. And why is it so? Because, as we have discussed earlier in the previous video, sale is not a mode but merely a title, and that the sale by itself does not transfer or affect ownership. The most that sale does is to create the obligation to transfer the ownership. Okay, so that would be for the object. And the second element of a contract of sale is, let's see. Okay. Cleaning ito. Clean na to. Okay. So, on price and consideration, of course, nilagay natin dito, it must be real or true. Kasi if the price is simulated, the contract is void, but the act may be shown to have been in reality a donation or some other act or contract. Therefore, or thus, a deed of sale in which the stated consideration had not in fact been paid is null and void. Okay. And by the way, note here the difference between the failure to pay. So there's a difference between failure to pay the consideration, meaning you already have identified, nagkaroon na ng meeting of minds, versus lack of consideration. Okay. For the failure to pay, the seller has a right to demand payment. Right? So that's what he's supposed to do. So the seller has a right to demand payment. On the other hand, the lack of consideration prevents the existence of the contract. Kasi nga, it's an essential element, no? Prevents. This is prevents, okay, the existence of a contract. And of course, in price or consideration, it must be money or equivalent. Kasi nga, if you are going to exchange it to another thing, then it becomes a barter. So, hindi na mag-govern ang law on sale. Money or its equivalent. Okay. Of course, as to the test in determining the certainty of the price, it should be sufficient that it be so without reference. So, nilagay na natin dito the test. It must be sufficient that it be so with reference to another thing certain, or that the determination thereof be left to the judgment of a specified person or persons. Question. Can a third person fix the price? Can a third person fix the price? The answer is yes. Okay, Article 1469, paragraph 1. Let me check. Let me double check the reference if this is correct now. Article 1469, if I'm not mistaken, class. 1469, okay. Article 1469. In order that the price may be considered certain, it shall be sufficient that it be so with reference to another thing certain, or that determination thereof be left to the judgment of a specified person or persons. This is, lagay na lang natin dito para hindi tayo mawala. 1469, paragraph 1. Okay. So that's the test. Now, what would happen if the third person acted in bad faith? No? So the third person acted in bad faith, you could see under paragraph 3 of Article 1469, if the third person or persons acted in bad faith or by mistake, the courts may fix the price. Okay. Now, if such person or persons are prevented from fixing the price or terms by fault of the seller or the buyer, take note, ito is 1469 pa rin yung natin ha, reference. 1469, Article 1469, paragraph 4, where such third person or persons are prevented from fixing the price or terms by fault of the seller or the buyer, the party not in fault, no? So, yung walang kasalanan, may have such remedies against the party in fault as are allowed the seller or the buyer, as the case may be. Okay. Now, if such person or persons unable or unwilling to fix it, doon naman tayo sa Article 1469 still, but now in paragraph 2, the contract shall be inefficacious unless the parties subsequently agree upon the price. Okay. So, just imagine, no, when we say price, sige, pwede ba yung third person? Oo. Check, 1469. Ngayon, what if yung third person acted in bad faith? What are you going to do? Article 1469, paragraph 3, the court may fix. Ngayon naman, if yung tao na yon has been prevented, no, by fixing the price, punta naman tayo sa paragraph 4, Article 1469 pa rin. And in the case that person is unable or unwilling to fix it, okay, 1469 pa rin tayo now in paragraph 2. Okay? I hope that is clear. Now, as a rule, gross inadequacy of price does not affect of a contract of sale. Kahit na sa tingin mo, mas mahal dapat yung benta niya. Kaso binenta niya ng mas mura, ano pang magagawa mo? Wala. However, it may be indicative of a defect in the consent or that the parties really intended a donation or some other act of contract. May iba din naman, di ba? Yung parang, uy, kaibigan ko naman siya. So, liliitan ko na lang. Yung kaya din naman, yung afford na afford. Okay? So, I think that's for price or consideration. Now, let's proceed with the capacity of the parties. Kasi one of the essential elements of the contract of sale is consent, right? And those who are allowed under the law on obligations and contracts, yun lang din, allowed din ng law na pwede maka-enter ng contract. Yun lang din yung pwede maka-enter ng contract of sale. And what are those? Diba? Yung capacity ng party. Diba? However, when we talk about necessaries that are sold and delivered to a minor or other person with the capacity to act, he must pay a reasonable price thereof. Pag nagbenta ka naman sa bata, tapos pagkain naman, hindi mo naman kinakailangan hanapin yung nanay niya, di ba? So, necessaries are those indispensable for sustenance, dwelling, clothing, and medical attendance according to the social position of the families. So, all persons who are authorized to obligate themselves may enter into a contract of sale subject to the exceptions as provided sa baba. So, these are the prohibited sales. So, nilagay ko na lang din what are those items. So, 1, 2, 3, 4, 5, 6, 7. Yung first, yung top is the husband and wife. So, tinag ko na din. This is Article 1490. This pertains to their capacity to sell, no? To sell from one spouse to another. Diba? So, pwede ba yon? The rule is that the husband and the wife cannot sell property to each other. Exception. Diba? So, pag may general rule, most probably may exception. In this case, meron nga. They can validly sell to each other when a separation of property was agreed upon in the marriage settlement or when there has been a judicial separation of their property. Now, what if hindi naman sila legal? Common law lang. Would this law apply? No? The prohibition also applies to common law relationships because of policy consideration and the dictates of, yung sa kabit, no? And the dictates of morality. Otherwise, the condition of those who incurred guilt would turn out to be better than those in legal, bawal nga sa legal wife. Paano na kaya yung sa kabit? So, yon. Okay? Okay, now before I proceed, just let me fix this one. Okay. Now, what would be the effect, of the violation? The effect of violation would be these contracts being entered into are considered as void and not merely voidable. But of course, who can question its nullity? Silagay na lang natin dito. Only the heirs and the creditors can question its nullity, and not the spouses themselves who executed the contract with full knowledge of the prohibition. Okay. So, only the heirs and the creditors can question its nullity and not the spouses themselves who executed the contract with full knowledge of the prohibition. Okay, so that's for the husband and wife. Remember in their capacity to sell and not to buy, to sell. Okay? Kasi this is different from the others na nandun sa Article 1491. So, let's talk about guardians and wards, In guardian, his capacity to buy, pwede din naman siyang benta. Pero, ito is yung mga prohibited sales, Si guardian, he cannot acquire by purchase, either directly or indirectly, Either, even at a public auction or judicial auction, either on his capacity as an individual or a person, or indirectly, like he looks for somebody to purchase that item na sa ward, under his guardianship. The sale is within the ambit of the prohibition if the guardian purchases the property from a third person, not directly from the guardian. Sinasabi lang niya is indirect, Directly, parang, basta in short, directly or indirectly, without the need of proof that a third party merely as an intermediary of the guardian. Here, the contract is voidable. Voidable in the sense that the prohibition is not permanent. I think this is it. The prohibition kasi is not permanent. So, let's take a look at Article 1491. Okay. The following persons cannot acquire by purchase even at a public or judicial auction, either in person or through the mediation of another. The sale is voidable for number 1 to 3 because this only affects private interest and that the defect can be cured by ratification of the seller. Kaya nilagay ko dito yung tatlo voidable kasi yung prohibition niya is not permanent. Okay. After the termination kasi of the guardianship, the prohibition no longer applies. Okay. Sige, let's make it red. Para makita. But I don't think red na red naman din siya, diba? For agents and principals, the agent cannot acquire by purchase even at a public auction or judicial auction, either in person or through the mediation of another, the property of the principal whose administration or sale may have been entrusted to him. So, exception for that is if, for example, the principal expressly gives consent to the sale of the property in the hands of the agent or administrator. So the prohibition is similar to that of the guardian and ward, and that the prohibition is not permanent. Okay, it's not permanent. Hindi din naman siya forever agent ni principal, di ba? So after the termination of the affairs of the agency, the prohibition no longer applies. As to executors and administrators naman, Article 1491, their capacity to buy the property of the decedent. No? So, the executor cannot, buy. The prohibition is also not permanent. So, ilagay na lang natin. I-copy na lang din natin dito. That's for the first 3. So, yung una, isipin nyo, pag husband and wife yan, general rule, hindi pwede. May exception to the rule, may dalawa, di ba? So, yun. For guardian and ward, agents, executors, yung tatlo na to, they affect private interest, right? So, these are voidable and can be ratified, and that the prohibitions are not permanent. Okay? So, after the affairs have been, tapos na yung role niya as guardian, so pwede na, right? Tapos niya yung role niya as an agent, pwede na din. Tapos natin yung role niya as an executor and administrator, so pwede na din. Okay? Of course, there must be yung parang you need to show na wala na talaga. He is not acting in the capacity of these 3, no? But in other capacity na. As to public officers naman, an employee, justices and judges, prosecuting attorneys, clerks of superior and inferior courts, other officers and employees connected with the administration of justice, and any other specifically disqualified. Yung isipin nyo na lang, these individuals, these persons, are holding positions na mataas sa, in a way, it's a society. Kasi meron din silang role at responsibility, di ba? These individuals, these individuals has, in a way, control, they administer, the administration of which of the items has been entrusted to them. So, the prohibition also applies to judges and government experts who in any manner whatsoever takes part in the sale. Okay. So, remarks, nilagay ko na lang din yan for public interest and public policy their capacity to buy, it's void, cannot be ratified. The nullity is permanent. Yung sa first three, the prohibition is not permanent. Yung sa last three, yung nullity niya is permanent. Can contract be ratified? No. Yung public interest at saka public policy remain paramount and do not permit of compromise or ratification. Okay? Yun din yung sa justices and judges and prosecuting attorneys by reason of public policy then. Okay? But in the case of lawyers, no, the prohibition in Article 1491 applies only to a sale or assignment to the lawyer by his client of the property which is the subject of litigation. So, siya yung counsel of record. So, of course, alam niya, di ba? Pero pag may final judgment na, tapos na, or hindi naman siya subject ng litigation, of course, that property can be allowed to be a subject of contract of sale. Okay. Yung keyword lang doon is it under litigation? Are there any issue regarding the property? So, if wala naman, or final na, at saka favorable yung judgment, so pwede na, the prohibition does not apply. Thus, the sale of a land acquired by a client to satisfy a judgment in his favor to his attorney is not prohibited if, okay, there's the big if clause, if said property was not subject to the litigation, and that the prohibition applies only to a sale to a lawyer of record and does not cover assignment of the property given in judgment made by a client to an attorney who has not taken part in the case, nor to a lawyer who acquired property prior to the time he intervened as counsel in the suit involving such property. Okay, I think that would be all for this video. So, next stop would be, so I think eto na muna, no? So, we will continue our discussion on the formalities, the formation and transfer ownership tomorrow, no? I'll really try. Sige. Thank you, everyone, and keep safe.